Good afternoon. Good afternoon, everyone. Yes. Can you hear me? Okay. I'm waiting for Sir to join. Okay. Sir has joined. Afeef sir, can you hear me? Afeef sir? So can you hear me, sir? Nityan is always worried about the camera. Camera out of focus. Afeef sir? Okay. Sir is there. So I'll quickly introduce Mohammed Afeef sir. Guys, I request two things. One is keep a constitution Bayrat. If you don't have a Bayrat, take a copy in the online version and keep it ready. Second thing is I want everyone to keep their notebooks and a pen ready. Please take down the topic which has been covered by Afif sir. I'm not going to repeat the same thing in a Muslim class, family law 2 class. Is it clear? And any questions we will ask sir after the session gets over. So kindly pay attention. Clear? Guys, is it clear? Hello, no reaction from third years. Third years, yes? Yeah, okay. Yeah. Uh, I'll introduce Sir. Mohammed Afeef Sir is a practicing advocate at the Alternative Law Forum. His areas of practice include constitutional and family related matters. His areas of interest include constitutional law, gender studies, and political theory. Today, Sir is going to speak on the topic Muslim marriage and divorce in Muslim law in the context of gender equality, other personal laws, and how courts have interpreted the same. We welcome you, sir, and thank you so much for accepting our invitation for this webinar. Over to you, sir. So, one minute. Huh? I'm not able to hear you. Yes. Even I can't hear anything from Sir Nityan. 2 minutes. So we are not able to hear anything from you.
Can you hear me now? Can you hear me
I
now?
will adjust the settings. So 1 minute.
Hello?
Moment. Okay. The mic is on. Yes, sir. So speak now.
Yeah, now you can hear me? Yeah, hello? Can you hear me? Hello? Yeah. So I think some of them are saying that they can hear me. Man, can you hear me?
No, sir. We are not able to hear you. Wait, wait, wait.
Hello?
Um,
Hello?
so I'm not able to hear you. If I
Okay.
mute,
Okay. I think some of the students are able to hear me.
Afif sir, say hello.
Yeah, hello. Can you hear me? Can you hear me? Hello?
Okay. Hmm. Hmm. Okay.
Can you hear me, ma'am?
Ah, yes, sir.
Can you hear me, ma'am?
Yes, sir. We can hear you.
Okay, great. So shall I start?
Hello.
Shall I start?
Hello, sir.
Yes, ma'am. Shall I start? Okay. Uh, there's no response from ma'am. Okay.
I'm not able to hear.
Can you hear me now, ma'am?
But I'm not. No, no. Uh, Please say hello.
Hello? Can you hear me?
No, sir. If you're saying hello, so I'm not able to hear.
Hello?
Sir, please refresh the page once.
Uh,
He again joined. I have to again go to the participants, no? Unlock. Okay. Yeah.
Hello? Can you hear me now, ma'am?
Say hello now.
Hello?
Hello.
Hello, yes, ma'am. Can you hear me?
Hello. Hello.
Hello, ma'am. Can you hear me?
Hello. So he's saying, hello.
Hello?
Conference call, but how do I take it? Call जाना है कहाँ जाना है call? No. Where? हाँ okay okay wait.
Can you hear me now, ma'am?
Sir, ad call नहीं आ रहा है मेरे में. Your phone and talk.
Hello?
ठीक है 1 minute. हाँ 1 minute. So please remove the headphone and speak. No.
Okay, one second. Hello?
Huh? You can hear him. No. I can't hear him. No. That's a problem. Everyone is able to hear. Only me. Okay, fine. We'll start. Okay. I'm not able to hear, sir. That's a problem. Okay, sir. Okay, sir. Okay, bye, bye, bye. Sir, I'm not able to hear. Maybe some problem. Please start, sir. Please start the session.
Can you all hear me now? Can you? Yeah. Okay. Great. So I'll go ahead now. Now it's always a pleasure to be with you all. And one thing is very important also, because not too long ago I was where you are sitting as of now as students, and it's very important. And it's a time in your life where you need to think, and you need to think independently. You need to think freely. You need to question all the things that you have learned in your past. As generally, I don't quote Einstein, but this is one of the quotes that really made sense to me. Is that common sense is a collection of prejudices acquired by the age of 18. All right, and it's a very important time period. These 5 years allow you to reflect and learn new things and unlearn some older things, right? The point of university, according to me, is to question all of those things that are understood to be common sense, that are understood to be strong established values. And essentially, the way I plan to do this, the way I plan to structure this presentation is first by talking about the Constitution. And I hope some of you have the Constitution with you all. And one thing is very important is my topic is Muslim marriage, divorce, and the constitutional promise of gender equality. Now, uh, what is the constitutional promise of gender equality? I'm hoping everybody's able to hear me now, as of now. Yeah. So, what is the concept of constitutional the gender equality, the promise of gender equality as per our constitution? If you all can just go through articles 14, 15, and actually 14 and 15 is good enough, right? We can start off with that. I just want to confirm once whether everyone can hear me, because then I'll. Okay. So if you look at 14, 14 is basically the state is the right to equality, equality before law. Everybody is equal in the eyes of law. That's what we have learned in a constitutional law class. The state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. Of course, this means, what does this mean? It means formal equality, at the same time, it means substantive equality. What does substantive equality mean? It means treating equally those who are equally circumstanced, and treating unequally those who are unequally circumstanced. Right? So, uh, that's one aspect of our equality code. If you go to 15, Article 15 is very important. I hope the Constitution is open uh, in front of you all. 15.1 states, the state shall not discriminate against any person, any citizen, okay, on grounds of religion, race, caste, sex, place of birth, or any of them. Okay, that's what 15.1 says. Right. Now look at 15.2. 15.2 is interesting. The reason why 15.2 is interesting is because the duty to not discriminate in 15.1 is on the state. Okay. But the duty to not discriminate is on the citizen in 15.2. Kindly read the wording of 15.2. Okay. Yes, that's right. That's right, Nikhil. No citizen shall, on grounds only of religion, race, caste, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to A, access to shops, public restaurants, hotels, and places of public entertainment. B, the use of wells, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds, or dedicated to the use of general public. Okay, 3 is an exception to 2 and 1 both. Actually, 3 is an exception to specifically 1, 15.1. Nothing in this article shall prevent the state from making any special provision for women and children. 4 is again an exception to 15.1, and 5 is also an exception, which talks about reservations and affirmative action, basically. But as of now, we're not entirely concerned with that. Now, where does the birth of our personal laws come in? Our personal laws, our family laws, are based on religious identity, correct? Right. So it's based on various religious scriptural traditions, and but of course it is based on it. But what in the constitution sanctions it is one question, very important question. Because when I talk about family law or any law for that matter, you have to relate it back to the constitution, because the constitution is the ground norm. Right? Is the ground norm, is the basis on which all other laws emanate. And if you go to the constitution, there are two types of right bearers. The question is that you have fundamental rights. The question is, who are the bearers of those fundamental rights? In some fundamental rights, it's the individual. It's the individual citizen. In some situations, it's a citizen. In some situations, it's a person, which means it's beyond a citizen. It can be a foreign national as well. And in some situations, it's a group. Now, if you go to, now you have 14, 15, 16, if you see, and of course 19, which gives you the freedom of expression, trade, commerce, movement, etc., all of those things. And then if you go to 26, 25 and 26, please go to 25 and 26. You go to 25 and 26. Subject to public order, morality, and health, and to other provisions of this part, all persons are equally entitled to the freedom of conscience and the right to freely profess and practice and propagate religion. Correct. And then, of course, the second part we're not too entirely relevant for the purpose of this lecture, but we can, of course, go through it. But 26 is also very important. Why is 26 important? 26 is important primarily because 26 is a right given to a denominational group, a religious denomination, subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right, A, to establish an institution of religious and charitable purposes, B, to manage its own affairs in matters of religion. This is crucial. B is crucial. C, to own and acquire immovable properties, so on and so forth, and to administer such properties. D. Now, the birth of a personal laws or the sanctioning of a personal laws in the constitution is relatable to 25 and 26. Okay. Now, let's enter the realm of personal laws. I mean, just before we enter the realm of personal laws, what does it mean to be equal, especially from the lens of family? When we talk about family, it is inevitable that you end up talk about gender equality, because here we're talking about formal equality within the law, right? Equal legal rights within the family, within marriage, within inheritance, uh, within divorce, leaving marriage, entering marriage, right? So these directly fall under the realm of Article 14, right? Because we're talking about specific legal rights within the family structure. Okay. So I hope ma'am is able to hear me now. Yeah, I'll just proceed. Now, if we how have how have the courts interpreted it in terms of gender? Okay. Now, if you look at certain judgments and certain recent ones, when you look at Article 14, if you look at the Sabrimala judgment, if you look at the Anuj Garg judgment, there's something called the anti-stereotyping principle. And through this case, you'll be able to understand the kind of imagination of gender equality our constitution, through various judicial precedents, is imagining. Okay. So in Anuj Garg's case, it's a very interesting case, a 2008 case, it's a must read. There was a section 30 of the Punjab Excise Act which prohibited the employment of women in a particular premise where liquor and other intoxicant substances were consumed by the public. There was a law under the Excise Act which prohibited women from employment. So now you have created two classes of people. You have created men and you have created women here as per 14. right? And I'm sure, I hope you all know the test of 14. In order to fulfill the test of 14, that there must be intelligible differentia, and there must be a legitimate state object, and there must be a rational nexus between the intelligible differentia and the state object. That's 14. Now, how did the state try to justify this law? The state tried to justify it by saying that this is necessary for the protection of women, so that untoward incidents of sexual harassment or untoward incidents towards women, it's a protectionist measure, correct? So that women are not harassed in such a places where people drink alcohol, people have intoxicants, etc. Another case is some provisions of the Factory Act in Madras High Court. This is another case. Some provisions of the Factory Act, this allowed women to work from 7 p.m. to 6 a.m. So here what you do essentially is that you're denying the employment opportunity to one class, primarily based on the danger posed to them by another class, right? And essentially what the court held is that is something very important. It's called the anti-stereotyping principle. The anti-stereotyping principle says, and it's a very progressive kind of a understanding of gender equality jurisprudence. I would suggest you read it. Otherwise, there's Gautam Bhatia's blog also, which basically talks about the. I can share it in the. I'll actually share it when I'm ending the lecture, in the chat on Anuj Garg. Basically, saying that you cannot justify a law on the basis of certain stereotypes attached to a gender. What are the stereotypes attached to gender? Most genders, you have attached masculinity to men, right? Where there is strength, there is rationality, there is ability to maintain a household. Similarly, there is the ability to give care, weakness, requirement of being protected. In some cases, in case of menstruation, there is the requirement of. There is a stereotype of impurity. What the courts held is that the state must ensure that no untoward incidents happen. The burden of protecting women cannot be placed on the women itself. Okay, it cannot be placed on disadvantage or cutting off the opportunity of employment to women. Right? It has to be based on the state's responsibility and society's responsibility to prevent such untoward incidents from happening. Right? Similarly, in the Sabrimala case, one of the major arguments was that in order for me to enter, the state justified the exclusion of entry of menstruating women into the temple on the basis of saying that it sort of creates an environment where where Lord Ayappa has the chance of losing celibacy, right? The mere presence of women automatically creates a sexual environment is basically the justification given by state. And another justification is that because of menstruation there is a sort of impurity attached, and therefore that impurity cannot be brought into any religious place of worship. Again, the court invoking Article 15 and 14, invoking the anti-stereotyping principle, said that both the fact that a woman is impure during menstruation is an entire stereotype. There is no scientific basis to it. There is no rational basis to it. And at the same time, that's what with respect to menstruation. At the same time, if you're talking about maintaining celibacy, the burden of celibacy, the burden of an environment which is celibate, which is anti-sexual, so to speak, cannot be on the woman. So you cannot deny the entry or the access to women to a particular place just because you want to keep it asexual. That burden cannot be disproportionately placed. So this is just to give you an idea This is just to give an idea of the kind of gender jurisprudence where our court has been going in the recent past. Anuj Garg was in 2008 and Sabrimala was in 2018, if I'm not mistaken. Of course, it's up for review now. That's another thing, but the order has not been stayed. Now, when we come to divorce and marriage, now let me come back to divorce and marriage. What are we talking about here? Basically, it's a very simple concept. It's not rocket science. We're talking about equal terms of getting into marriage and equal terms of getting out of marriage and divorce. Correct. And if we look at if we look at um, how this claim of equality within personal laws has been understood, it's a quite a controversial and fascinating thing. And essentially, and this is the way I place it. Okay, this is I'm going to be mixing some of my understanding with my with factual understanding of law and the legal position. Is that in the colonial times, in the colonial government just looked at Indian subjects as subjects. They are they are people to be administered. They are not rights-bearing citizens. Whatever the colonial government gave to the people, right? Whatever the colonial government gave to the people was a form of charity. It was not a claim, a rightful claim from a rights-bearing subject. Post our constitution, our fundamental rights, and if you can read 13, Article 13 is very important to read. Okay, just hello, can you hear me now? Hello,
Guys, wait, he will check. Okay.
hello. Okay, all right. Now, if you go to 13, let's look at 13. 13 says 13.1 says that all the laws enforced in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part is the fundamental rights part, shall be void. Then subsequently for the future, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention, any law of the state legislature or the central legislature makes any law shall be to the extent of contravention of this part, fundamental rights, be void. Which means that if there is a law which has an unequal effect on two classes of persons, in this case is man and woman, that should be void, technically speaking. Except that if you read the question, if you read law, the definition of law, 13.3, please read 13.3. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. Logically speaking, it should come under that because definitely it would come under custom, personal law would come under custom. If not, see, when did our enactment started coming? When was the Hindu Marriage Act enacted? 1955. Much later, 5 years later to the enactment of the Constitution. Right. Divorce Act existed previously, but then it was later amended in 1988. Okay. And our Parsi Marriage Act also came later on. Correct. When it was codified, it became law, undoubtedly. But we're talking about a time period when before it was codified. Okay. And there's a very important case called Narasu Appa Mali. It was a Bombay High Court case, which was then later on affirmed by the Supreme Court in some ways. I'll just read a paragraph from there. It's very important for you to understand, especially in the context of Muslim personal law. It says, Justice Gajendra Gatkar in State of Bombay versus Narasu Mali. I'm reading MP Jan over here. So, the framers of the Constitution wanted to leave personal laws outside the ambit of Part 3 of the Constitution, fundamental rights. They must have been aware that the personal laws needed to needed to the reform in many particulars, and in fact, they wanted to abolish these different personal laws to evolve one common code, the question of the Uniform Civil Code. Yet they did not wish that the provisions of the personal laws should be challenged by reason of fundamental rights, and so they did not intend to include personal laws within the definition of laws in force. Subsequently, a women's group in Ahmedabad had challenged the practice of polygamy. This case was cited, saying by the Supreme Court, saying that personal laws cannot be challenged on the basis of the constitutional rights given in Article 14. Quite a problematic thing. But now, when it comes to Muslim law, it's very important. So let's just park this for a moment. The relationship between the family laws, family/personal law, and the constitution. Understand it. Somewhere through judicial precedents, the courts not have ensured that the personal rights are not subject to the personal law. Differences of gender equality are not subject to the rights enshrined in the fundamental rights. Okay, this is a continuation of the colonial government's policy. What was the colonial government's policy? One of the most important things is that we will not intervene in your family matter. Right. Keep that aside. Now, when we come to Muslim marriage, what is the difference between Muslim personal law and, let's say, Hindu personal law or Christian personal law? I mean, if it was interactive, I would have asked this question, but since it's just me telling everybody, I'll just respond. Is that in Hindu personal laws, especially now, where we are standing today, you have the Hindu Marriage Act, you have the Divorce Act, you have the Parsi Marriage Act, right? You have the Special Marriage Act. In each of these acts, there is a specific description of what constitutes a legal marriage. In Divorce Act, in Hindu Marriage Act, you have certain rituals that you have to complete, Saptapati, etc., all of those things. And similarly, in each of these acts, there are grounds on the basis of which both parties can claim divorce. Mental cruelty, adultery, desertion, venereal disease, imprisonment by one of the parties, correct? And cruelty, one of them being a huge one that is litigated. Impotency, yes, that's true. So these are the grounds in which. In Muslim personal law, with the exclusion of one or two acts, there is no description of what constitutes marriage, right? By a statute. Of course, there is a description through various jurists, through mullah, through various textbooks that you might be learning in your family law class. What applies in cases of Muslims in family law is something called the Shariat Application Act 1937. I'll write it down. Shariat Application Act 1937. What does this act talk about? This act is very simple. It does not tell what is the definition of marriage. It does not tell the grounds of marriage. It does not tell what are the various proofs that you have to rely on in cases of marriage, etc. It does not do that. It simply says that the Sharia shall apply to the Muslims of India in these many subjects. What are those subjects? Let me read out those subjects to you. Succession. marriage, dissolution of marriage, divorce, maintenance, guardianship, gift, trust properties, and work. So it just says the subject areas which it covers. It does not get into the integrities and definitions of what it constitutes, etc. How are we supposed to know those things? We are supposed to know those things through something called Islamic jurisprudence or Islamic theology or what is called fiqh in Islamic traditions. Unfortunately, the situation has become that I am no expert in Islamic theology. I am a lawyer. My area of interest, my cup of tea is the law, is the statutes, how it operates in courts. But unfortunately, because of the structure of the law, we have to get into the jurisprudence of what it matters. And this is a very tough thing to do. Why is it a very tough thing to do? I'll explain. So there are four sources of Islamic law. First is the Holy Quran. The Holy Quran is understood to be the word of God by Muslims all over the world. Then you have the Sunnah. What is the Sunnah? Sunnah is the sayings and the doings and the deeds of the Prophet as recounted by his companions at that point in time. Correct. Then, how do they work basically? Who wrote those sayings? There were narrators, specific narrators of those hadiths. Correct. And those narrations were then later on compiled. They were later on compiled by various schools such as Bukhari, Muslims, okay, Abu Muslim. So these are basically people who are author jurists. What does that mean? They mean what they do is that they go back into history. They have a particular method, and they see the narrations of the companions of the Prophet and what they have said with different topics. So that there is a huge compilation of volumes and volumes and volumes of hadiths. Now, who interprets law on the basis of these two these two uh, these two sources of law are the author jurists. There are various schools, are the ulama, it's called the scholars, basically. And within those scholars, there is a yes jurist. Now, within those scholars, there is a hierarchy. Mufti being one of the highest. Mufti is somebody who is authorized, who has to have a Mufti certificate. There's a degree course for that, and that person has the authority to give a fatwa. What is a fatwa? Very important question. Fatwa is simply a basically क्वेश्चन ऑफ लॉ होता है ना कि कोर्ट में जाता है एक क्वेश्चन ऑफ लॉ होता है कॉन्स्टिट्यूशनल व्हेन यू गो टू सॉरी फॉर शिफ्टिंग टू हिंदी व्हेन यू गो टू कोर्ट and constitutional court especially have to deal with specific questions of law or questions of constitutional law. Similarly, there is a question of law that is raised, such as can a nikah be conducted through a Skype? I mean, I'm just putting an example. Are the use of cryptocurrencies allowed in Islam? These are specific problems that come through the evolution of time, and jurists examine these problems on the basis of the hadith by drawing certain analogies, principled analogies. I hope I'm clear. Maybe one time I just want to ensure that everybody is with me, that some people are not completely lost me. Okay, okay, fine. Okay. Now, similarly, there are various schools. Okay. Now, in India, if we go back to India, there are four schools, jurists. The people who compile the hadiths are different, and the people who are the jurists are different. The compilers are simply people who write the textbooks, so to speak. That is Bukhari, Muslims, etc. They write the hadiths. The people who interpret them fall under some of these schools. In the Sunni tradition, you have the Hanafi school, you have the Maliki school, you have the Shafi school, you have the Hanbali school. This will be part of your textbook. In the Shia school, there will be Itna Sharia school, Ismaili school, Hoja school, Boraz school, And Zaidiyas. Zaidiyas are not here in India. Somebody is asking a question. Okay, I'll come back to this question. Yeah, of course, of course. So I'll come back to this question. So whatever questions are there, I'll come back to them, and I'll keep at least around. I don't know if you have enough time. If we can extend the time to 15 minutes, because we lost the first 15 minutes. But anyway, so these
Yes,
are
sir.
the schools. You can extend it. Okay, great. That's great. Okay. So these are the schools. Now, on the basis of these schools, India largely, on the basis of these schools, around 80, 75 to 80% of Indians largely follow the Hanafi tradition, okay, which is a school of thought. Now, of course, these pass on from generation to generation, often unquestionedly. Now, if we go into, now let's get into Muslim marriage. And now you will see the connection. Now, since I'll go about Muslim marriage, little bit technical details which you uh, might have basically dealt with in class as well. But I'll just deal with them. And while I'm dealing with them, I'll slowly move into the constitutional problem. What is the constitutional problem? Okay. Now, let's get into Muslim marriage. As per the Hanafi tradition, and largely there is a more or less consensus about this. Marriage, entering into a marriage is a contract in Islamic law. I'm like some very loud voice. I'm not able to. Very loud voice. Hello. Oh, okay. Ah, yeah. Okay, it's off. So, what does it mean? It's very important that it is a contract, primarily because the terms and conditions of every marriage, other than a Muslim marriage, is pre-decided. The duties are pre-decided. The rituals are pre-decided, right? There is no negotiation between two parties. What does this mean in the case of a contract? It is, in fact, it gives a great deal of power to the parties that are entering into the contract. What does this mean? What is required? What are the essentials of a Muslim marriage? Much like a contract. Hello, can you all hear me? Ah. Much like an essential of a contract, you require a proposal, and you require an acceptance of the proposal, and you require meher, something what is called a meher, which is a token amount, right? Yes, of course, competent parties, right? Yeah, dower is meher. So a dower is given by a male member to the female member. So, and that amount does not need to be a high amount. It can be an agreed amount, whatever amount is agreed. Okay, and there needs to be uh, witnesses. Okay, there is a debate on whether what are the number of witnesses. So in the Hanafi tradition, for example, they require two male witnesses, or in the case absence of two male, uh, two female and one male witness. Correct. And essentially, technically speaking, as per Hanafi tradition, there's nothing called registration, right? But often, I mean, you need not have a nikah. But if you have a nikanama, right, it can be an oral contract. But the problem with oral contracts is that it is a very dangerous thing. It does not allow you to have a clear understanding of the terms and conditions of engaging with each other in marriage, for example. So, I mean, in most of my clients, I try to tell them, please have a nikanama. Don't ignore this. Register it in any particular masjid, jamaat committee, and it basically looks very simple generally. Okay, it basically has a name, parent's name, address, stating that I am willing to enter into this marriage contract with you, etc. But it definitely can be more than that, is what I'm trying to say, right? Just before I go ahead, there are absolutely correct, there are sahih marriages, there are facet marriages. There are few. I mean, I'm sure some of these things ma'am will talk to you about. Is that there are some marriages that cannot happen. There are void ab initio. One thing, one of them is marrying your immediate family members, bloodline. That cannot happen, right? Similarly, marrying somebody. So of course, in some of these traditions, polygamy has been sanctioned. Hanafi tradition also it has been sanctioned. Similarly, it is a discriminatory position of law in which a woman cannot have more than one husband, while a man can have up to, as per the tradition, I'm saying, there are some different traditions within it, can have up to four wives. Now, this is even within the tradition, even within Hanafi and Shafi tradition, has to be based on the consent of the first wife and the second wife, and so on and so forth. Right. Yet it is discriminated because one is allowed to have another marriage while maintaining another marriage as well. That's one thing. But what does it mean to have a contract? So there are various organizations who are more concerned about gender justice and women's rights, such as the Bharatiya Muslim Mahila Andolan, BMMA, okay, who have come out with specific nikah namas. Those nikah namas are so extensive. They're so extensive because they are saying they explicitly prohibit the use of triple talaq. They explicitly prohibit polygamy. They explicitly prohibit the unilateral leaving, right? Unilateral leaving of marriage, right? They explicitly prohibit those things. So what I'm trying to say is that you can secure your rights, whether it's meher, whether it's dower, whether it's maintenance, whether it's custody of children, whether it's how you want to leave the marriage, on the basis of a nikah. You can set those terms, and those terms can be agreed on by both parties. And essentially, that's what BMMF tries to do. And this Bharatiya Muslim Mahila Andolan, Bharatiya Muslim Mahila Andolan. Somebody is asking for the full name. Okay, you can Google them. They have done a lot of work on triple talaq, etc. Now, this is a marriage. Now, what is divorce? How do you enter in? What is the sanction form of divorce? There is two sets of, if you categorize it, there are two categorizations. One is divorce at the instance of the husband, one is divorce at the instance of the wife. Now divorce at the instance, and third one is called talaq, okay, one is called khula is the instance of the wife, and third is called mubara is mutual consent. I'm just writing it down. Talaq, wife, at the instant of wife, it's khula. At the instance of mutual consent, it's more mutual consent. है So on these basis, now what is the? I'll start off with the talaq at the instance of the husband. Basically, talaq is as always the instance of the husband. Now there are only two sanctions forms of talaq. That is talaq ihsan and talaq hasan. Okay, and third is talaq bidat, which was famously understood to be triple talaq. In fact, all three talaqs are triple only. There's nothing unique about it. What is unique about talaq bidat is the giving of those three talaqs in one sitting, and then it becoming irrevocable in one sitting itself, or in one time period, one breath, so to speak. What is talaq ihsan? Talaq ihsan is also three times. Talaq hasan is also three times. The only difference is the time period. Okay. These irrevocable in the case of triple talaq when you say it immediately. Okay, and say it all three in one go. Now there is something called tuhur. Tuhur is the time between two menstrual cycles. Okay, and what essentially happens in the case of talak ehsan, okay, is that in one tuhur you can give the three talaks. Okay, in one time period between two menstrual cycles, you can give them. You would have to wait for the iddat period. Your iddat period is basically a period of three menstrual cycles. Basically, 3 months. There are different calculations. Some people say 6 months. Some people say 3 months, 6 months, 4 months. Basically, it has two purposes. The purpose of iddat is basically to ensure that if there's a pregnancy, iddat period, how is it marked by? It's marked by the lack of physical relationship between the two parties. One thing is very important. When the iddat period starts, is that when the physical relation, when the talak is said, okay, when the third talak is said in the talak ehsan, right, coupled with non-physical relations for a period of around three menstrual cycles. They the period basically is to ensure that basically pregnancy, if there is a pregnancy on the basis of with that husband, it's clear that it's because of the husband, right? I mean that's the logic and sort of logic of the period, and also it's just a cooling off period. It's called a cooling off period where you have time to think these things through. Talaq Hasan is basically after each cycle, three cycles, 3 months, you pronounce uh, it. How is it calculated? I'll answer this. So there are two questions as of now towards the end. Okay, Talaq Hasan. Okay, you say it in three different cycles, not in one cycle, right? Okay, and now in the middle of this, in both cases, in Talaq Hasan and Talaq Ihsan, mediation is mandatory. What kind of mediation slash arbitration is mandatory? One member from the wife's side, one member from the husband's side, correct, and one neutral member, right? Where they engage in mediation, okay, and try to resolve it, try to think it through, and in that cooling off time period, you make a informed decision to separate or to stay together, right? After the declaration of the third talaq in Talaq Hasan, then it becomes irrevocable. Then you have to marry again. Okay. In Talaq Hasan, you have to wait till the iddat period is over. Okay. You have to wait till the iddat period is over. So simply put, okay, since we are here, how is it calculated? The date from separation. It's not necessarily separation. It's not necessarily judicial separation. They don't have to live separately. A talaq can be said. Now, in Talaq Ihsan, the iddat period starts commencing after the proclamation of the third talaq. Right, correct. Then the iddat period takes 3 months, it gets over. Right. So you have 3 months to 6 months, whatever the calculation is. In Talaq Hasan, you don't give talaq in the first tuhur, the period between the menstrual cycles. Just give one talaq there. Then in the second tuhur, you give the second talaq, and in the third tuhur, you give the third talaq. So when you give the third talaq in Talaq Hasan, it becomes irrevocable. So these are just some technical details. If that period is, this is the calculation. If the period begins in Talaq Ihsan from the third proclamation of divorce, and Talaq Hasan, it begins with the first proclamation, right? But in Talaq Hasan, you don't give the three proclamation within one thing. I hope I'm clear. Is it clear, guys? It's a little bit technical. Okay, so this is one. Talaq bidat is this thing. Okay, then if we move to, if we now understand one thing, each form of these talaq, each of these forms, okay, are often unilateral. So the question then comes is that there is a lot of hoo-ha about triple talaq. Triple talaq was said to be illegal. Okay. The question then comes is that I, as a husband, can I unilaterally, without any reason, following this procedure? I am following this procedure. Remember, I am following Hassan and Hassan, or one of them I am following. Can I unilaterally, without any reasons, valid reasons, give talaq? Can I do that? Nothing in the nothing in the dominant Hanafi tradition stops me from doing that. But the courts have seen otherwise. There are two very important cases over here. Now I'll talk about those cases. One is the Allahabad High Court case called Rahmatullah versus State of UP. Okay, I'll write it down. Rahmatullah versus State of UP. Okay, and the second is a very important case is Shami Mara. In fact, Shami Mara is a much more important case than Shaira Banu, which is a triple threat case. And I'll explain why. Allahabad High Court and Rahmatullah versus State of UP held that basically mediation is mandatory. Okay, mediation is mandatory, and you must provide the proof of mediation. If you are saying that I'm a husband, okay, there is a claim of maintenance, okay, made by my wife. Okay, maintenance is a completely different issue, but I say that I have given talaq. Now it's not enough for you to bring a talaq nama. It's not enough for you to bring two witnesses and say that ha inhone talaq diya. It must be proved that the mediation or arbitration has indeed occurred through documentary proof, electronic proof, or witnesses, etc. That's very important. Now, interesting case, Shami Mara. Now, Shami Mara's case is a 2002 case, Supreme Court. The couple married in 1968 in accordance with Sharia, the Sharia requirements. In 1990, okay, they have around 4 children, if I'm not exactly remembering. Husband stops maintaining children. Okay, wife makes an 125 application. Okay, in 1990. Okay, sorry, a maintenance application. Okay, now judge rejects it in the family court, saying that divorce has already been given. Okay, how has the divorce been given? The husband responds in his so whenever you make an application, maintenance application, the respondent files objections. In the objections, the husband says, "Okay, I have given 1986 I have given divorce in talaq in 1987 itself. Just because my wife doesn't know doesn't mean the divorce is complete." Okay, and when the wife made the argument that I should know at least that the divorce has been given by you. You cannot simply give it unilaterally without my knowledge. He said, so I now you know. Now you know in the application I've written no. So now you know. She appealed this decision. It was maintenance was denied to her. Okay. She appealed this decision. See, primarily because it's very important to remember, sorry, there's one clarification. She filed it under the 1986 Act. The 1986 Act initially because of the prohibition of application of 125 in Shah Banu's case. I mean, because of the in 125 was allowed as per Shah Banu case. Then 1986 was a specific law for Muslims to claim maintenance only during the Iddat period. So he was saying that Iddat period to khatam ho gaya. It's over. 1987 I gave you divorce. Correct. She is like, no. Uh, and she appealed in High Court. In High Court, the High Court says that since you did not know about the divorce since from 1987 to 1990, and now you know about the divorce, you will get maintenance for that time period, between 1987 to 1990. So it will be calculated like that. Now, Shami Mara takes it to Supreme Court. Now, Supreme Court says it is that no, this argument cannot stand. The reason it cannot stand is that there are certain essentials in a divorce which has not been completed by the respondent. What are those essentials? There are three important things. Okay. First thing is that and this is very important because this was never brought in before, that talaq cannot be given without any reason whatsoever. In fact, there must be a reasonable ground on the basis of which talaq is given. Okay, a reasonable cause must be there. Before the talaq, same thing. Before the talaq, there must be a reasonable attempt at mediation, right, in the prescribed format, in the period of time, in the time period of it. And at the same time, the fact that talaq has been declared must be communicated. So what does it hold? It directly, automatically holds talaq e bidat illegal, right? When it's prescribed in Shami Mara, is the judicial prescription of how the procedure of talaq must happen on behalf of the man. Okay, it says that this is how talaq must happen. What Shaira Bano does is Shaira Bano simply says that this is what you can't do. It's already implicit in Shami Mara, saying that this is the procedure. It already excludes talaq ki bidat. Here and it's very important to remember, when we go to Shaira Bano's case, the triple talaq case, and this is a very big misconception by many people, many learned people as well, media also, that triple talaq was not held to be unconstitutional. It was held to be illegal as per the doctrines of Muslim personal law, as per Hanafi tradition, as per Shafi tradition. It was not held on the basis. There's only one person who held, that is Justice Nariman, in the five-judge bench, holding it to be unconstitutional. Why? Why is that the case? Okay, park this for a second. Why is that the case? We come to woman. Divorce are the instance of woman. Now, divorce are the instance of woman. There are several kinds, but there are two which are uh, very common. Talaq e tawfiz. Talaq e tawfiz basically is that when the husband delegates his power to divorce to the wife, and the wife basically uses it. One thing is khula. Now, khula is basically it is a contested. Okay, it is at the instance of a woman, but there was a huge debate in the before 1939, and in that time period, in the colonial time period, somewhere around late 1800s to 1939, saying that whether the in a khula nama, whether the husband must consent. So it's the mutual consent again, no? It has become mutual consent. Mubarak, it's much like Mubarak. If the husband is consent, see, if in talaq the husband can give himself on the basis of a reasonable cause, the question is, why can a woman not give khula on the basis of a reasonable cause? Why does the husband have to consent? Now, as a result, what happened was that the Hanafi fiqh, they started saying that no, the husband must consent. The Shafi fiqh started saying that no, they don't need to consent. A wife will give a reasonable cause, but they have to give up the meher. Now, what happened very interestingly is that Muslim women who are in marriages, in bad marriages, that they wanted to leave started converting to other religions in order to leave those marriages. This then caused the ulama, the Muslim community, and the legislature at that point in time to enact something called the Dissolution of Muslim Marriage Act 1939. Now, this act, okay, I'll write it down. Dissolution of Muslim Marriage Act 1939. Okay, now this act, like Hindu Marriage Act, right, judicial separation and divorce, dissolution, and it has specific grounds. So I'll read out some of the grounds. That the whereabouts of a husband have not been known for a period of 4 years, that the husband has neglected or failed to provide maintenance for a period of 2 years, that the husband has been sentenced to imprisonment for a period of 7 years or upwards, the husband has failed to perform without reasonable cause his marital obligation, impotency, insanity, and several other things. Cruelty. Yeah, same. Except the conditions, the same like Hindu marriage ground, except far more stringent conditions. If you look at Hindu Marriage Act or Divorce Act, the period of desertion is 2 years. If you look at the Muslim Marriage Act, the period of desertion is 4 years. Correct. If you look at imprisonment, this thing itself it has to be 7 years punishable, an offense punishable by 7 years. No such condition is present in any of those other laws. Right. Of course, this one is a little more open that when the husband has failed to perform without yes. But desertion in Hindu Marriage Act and in Christian Marriage Act, I think as per my knowledge, is 2 years, which is a clear deal. So you have Muslim woman on one hand saying for the same reason how to get out of this marriage, a Christian woman and a Hindu woman on another hand saying for the same reason, desertion, how to get out. But the Muslim woman has to wait for a longer period of years. Right. So 7 years imprisonment. Correct. So that is with respect to imprisonment. This is with respect to desertion. The previous point. Oh, okay. Is it 7 years? Okay. So even if that is 7 years, then there are several other grounds as well. Okay. Which. So here there is something called cruelty. Right. Now cruelty is defined in a particular way. Right. But the cruelty in Hindu Marriage Act and in Christian Marriage Act is open, and Parsi marriage is open to interpretation. It can be any other form of cruelty. You have to just convince the judge. It does not prescribe. Over here, it says that the husband treats her with cruelty, that is to say, habitually assaults her or makes her life miserable by cruelty. Uh, okay, B associates with women of evil repute. It gives a basically a sort of 5 6 steps, um, 5 6 steps to establish cruelty. Other than that, I think there are certain other grounds which are present in the Hindu Marriage Act and in the in the in the adultery. Is adultery present here? I am just checking over there. You can do the comparative. Basically, the point is that there is a differential conditions in the grounds. While the conditions of the Hindu Marriage Act and the new 1988 Divorce Act is more or less the same. It has slowly become the same because one provision on mutual consent was challenged in 2008 in Supreme Court by I think in order for mutual consent in the old Divorce Act, for it to be applicable, they have to wait for a period of something like 4 years. But all the other laws, they have to wait for a period of 2 years. So this is one thing, right? Insanity is yes, yeah, insanity is there. 2 years, it is. Insanity is part of it. In some ways, Muslim personal law, Muslim personal law is actually beneficial. In some ways, it is not. Okay, there's a lot of noise. Huh. So I'm saying, in the context of a practicing lawyer, म्यूचुअल कंसेंट के लिए आपको वेट करने की कोई जरूरत नहीं है. दूसरे लॉज में कम से कम अभी तो 6 महीने है मेरे ख्याल से. You have to wait for 6 months for to do judicial separation for 6 months for sure in order to ensure the mutual consent. In Mubara, you can simply go and get the divorce immediately, right? Through mutual consent, right? So there are some beneficial parts that are there directly under this, and there are some disadvantage parts. So this is one thing. Now this is the divorce, marriage and divorce, both technical aspect. Now the interesting part, connecting it to the constitution. Can I challenge this? Can I say? Can I say that certain practices within the, for example, Muslim personal law is discriminated towards women under Article 14 and Article 15? Can I challenge this in the in the Constitutional Court? Unfortunately, because of the Shaira Bano judgment, because of the Triple Talaq judgment, I cannot do that. The reason I cannot do that is because the majority in that case, there was a minority who held that personal law. See, go to 13. Remember, I was talking about 13, Article 13. Whether the customs prescribed in the Muslim personal law fall under law. The courts unfortunately held no, that it does not fall under law. Only Justice Nariman held that because of the Shariat Application Act 1937, it being a statute and it enabling uh, various practices in the Muslim personal law, it would fall under 13.3 and therefore be able to be tested against the constitution. If the majority judges of Shaira Bano allowed allowed or held that the practices under Muslim personal law can be constitutionally challenged, they would have held triple talaq to be unconstitutional, not illegal, not illegal as per Islamic law. What the majority bench in Shaira Banu's case did was to hold talaq-e-bidat illegal as per Islamic law, not as per constitutional law. So here there is a very important point, a move that needs to be made, a lacuna in the law, that primarily because Muslim personal law is not present in a statute, one cannot challenge it. Practices, one cannot challenge it on the basis of the promise, on the basis of the articles that consolidates the right, gender equality in Article 14, 15, 16. And I think with that I will conclude my lecture. And there are about 3 questions that were asked. I think I'll just sort of deal with them. I'll start with the first one. Somebody had initially asked certain question, one question. I'll just deal with that. This is Rituka. Rituka. Okay, sir. Referring to something you said priorly, how do we change the situation of women as being considered a protected class, reasonable classification under the constitution, and move towards a scenario in a society where the burden doesn't lie on women to be someone who need protection? I this is more of a social question. This is more of a question wherein it's a question of perception. It's a question of what gender means. It's a question of us to question certain, and that's why I started the today's lecture. I started off with the Einstein's quote. What is the quote? Is that common sense is a collection of prejudices that is acquired by the age of 18. It's very important to question what is commonsensical about gender. What are those gender roles that are ascribed to women? What are the gender roles that are ascribed to men? Okay, those stereotypes. Okay, it's very important to question those stereotypes and to change that. For example, one way that had been done in Sabrimala is to simply say that you can't say that mere presence of a woman in a particular area threatens your celibacy. If you want to be celibate as a man, please look down. Don't look at the woman. Don't engage with her. So I'm saying, so this is one way the courts have done it. In another way of doing it is that of course you have to one. I'll just sort of describe one or two very important books, and this is little outside the law, but this is Simon de Beauvoir. फ्रेंच नाम है तो स्पेलिंग गलत ही होगा मेरा लेकिन साइमन de Beauvoir, The Second Sex. Okay, it's called. It's a absolutely important book to read. Now it's a very big book. ठीक है. If you are not able to read that book, Nivedita Menon's book is there. Nivedita Menon's book. Something like that. Just hold on. Seeing like a feminist. But I'm just trying to. Seeing like a feminist. This is a small book. छोटा सा book है. But if you start reading that book, it will really question those categories of gender that is already established, right? And this is a very important thing. The second question: aren't personal laws also subject to the limitation laid out under the Constitution? Personal law, like I answered earlier, personal laws, there might be other provisions in the Constitution which might sort of affect the personal laws or customs and etc. But the fundamental rights chapter, right? If it is not a statute, remember Hindu Marriage Act was not a statute in 1952. Okay, in 1952, Narasu Appa Mali's case, at that point in time, it was just practice. It was just regular. It was like Muslim personal law. It was a regular practice. So when the courts have held that this regular practice is not law, does not fall under the definition of law, how can you test it against the chapter fundamental rights chapter, right? Later on, it became law, Hindu Marriage Act. Okay, when it became Hindu Marriage Act, when Divorce Act became Divorce Act 1988, then these became statutes. Then these became very clear laws that were legislated by Parliament. That could be questioned. But as of now, we don't have a Muslim Personal Law Act which defines specifically what constitutes marriage, what constitutes divorce. It is not. There is no equivalent of a Hindu Marriage Act. There is no equivalent of a Christian Marriage Act or a Divorce Act. There is no equivalent of a Parsi Marriage Act in Muslim personal law. So Muslim personal law to challenge aspects of it with respect to marriage cannot be done on the basis of fundamental rights as per the court's interpretation, Shire Bano, and that's the reason why I see Shire Bano as a bigger loss than a win. The state, okay, so where's one thing, sir? But so there's Prasad's question. Nikhil Raj, the state cannot basically have any power to change the custom or practices which form the basis of personal law. No, they can. Is that the same person? No, Nikhil Raj. Okay. No, they can. They have done it. They have done it on the basis of Hindu Marriage Act. They have done it on the basis of Divorce Act. They have done it on this thing. They have done it on the basis of legislations. When I say state, I don't only mean, I mean parliament. I mean the legislature. When you are legislating any particular thing, you are suppressing certain customs and you are upholding certain customs. Certain customs are necessary for Hindu marriage, right? So you are intervening in that. You have intervened in that. You have not intervened entirely, so to speak. You have limited your intervention when it comes to Muslim personality. Then this one's question, Sai Prasad. Sir, But by disarming the judiciary from intervening from personal laws and only allowing to change the legislation allow for an unpractice of personal law, yeah. And that's what I'm trying to tell you. That's exactly what I'm trying to tell you. Prior to, you are not allowing largely women who are disadvantaged in different situations to petition the constitutional courts of this country to ensure that the fundamental right of equality is enforced through the court. You are not doing that deliberately. And I'm saying that you're not doing that, you are not doing that specifically in personal law. There are other customs which form law. Those have been questioned. There are other customs because if you see Article 13, it talks about customs. Law includes ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in utility. So custom is not. So there is a particular custom. That custom can be. You have to prove it that it is a custom. So yeah, I think that's about it. So okay, Sai Prasad has asked one more question. But isn't it because Muslim personal law is derived from the Quran? So in a way that the codified version that I'm not able to understand. समझ में नहीं आया. But isn't it because Muslim personal law is derived from the Quran? So in a way, that's the codified. Oh, okay, okay. You're saying the Quran is the codified version. Yes, the Quran is the codified version of it. Yeah, yeah, correct, correct. Yeah. There's only one act, that is a Muslim dissolution of marriage 1999 act, in which only women can apply, men cannot apply in that act. Yes, that's true. It is the codified version. But you see, this is then becomes a big problem. Now you have judges sitting in constitutional court interpreting the Quran. You know what I'm saying? I'm saying that it's a logical fallacy. Why is it a logical fallacy? Is because it's not their expertise. The science of fiqh and theology is an independent discipline. It's like you're asking a chemist to be a civil engineer. उनके expertise ही अलग है. The expertise is entirely different. The expertise of a judge is got to do with statutory law, is got to do with constitutional law, is got to do with this tradition of law, which you have inherited. I mean, whatever you're drafted the constitution, there are parliament, legislature. The structure of law is entirely different from the structure of fiqh or law or theology that is part of the Quran. In the Quran, the judges, the Islamic structure of the structure of Islamic law, judges don't interpret the law. Judges simply apply the law that has been interpreted by the ulama. So the structure of is entirely different. There is no legislation in terms of a kind of a parliament from the Quran, from the sources of the Quran. There is interpretations that come up. There are often conflicting interpretations where people have very long, lengthy debates, where muftis have very long, lengthy debates, which is never ending, where there is no resolution in some situations. There is no centralization. एक सेंट्रल अथॉरिटी नहीं है. ऐसा नहीं है कि there is a head priest or there is a this head mufti that will say that this is the position of law in this. There is a diversity. There is no one. There is no certainty in it. So these are the lot of problems. If you get into that, if you get into interpreting the Quran, and if you get into this thing, it's an endless cycle. It's a very tough thing to do. Is basically what I'm saying. Now, if one were okay, now if one were to decide what can be allowed from a religious document based on subjective interpretation of social thinkers versus the more conservative thinking, it will lead to eventual chaos of differing views of customs. That's true. Like we see what is happening with the committee for saying Sabrimala judgment, even though that is a court judgment and not a legislative action. Right. But you see, the difference in the Sabrimala judgment and here is that in the Sabrimala judgment, the Devaswam board is a statutory authority. It is coming under the definition of state. There is a government funding to Sabrimala temple. It comes clearly under the definition of state, right? As per Article 12, right? That board is a state. The rule which disallows women to enter uh, of that age gap who are menstruating to enter the temple is statutory. It's there. It's written down. Such a law can be challenged. And similarly, even when Shamimara judgment was given, even when the Triple Talaq judgment was given, the conservative thinkers were absolutely uncomfortable. Already, Muslim Personal Law Board impleaded in that case and basically tried to say that you cannot do this. So that is a conflict that is inevitable, right? But our constitution tries to ensure that the citizens are equal not only with respect to the government but with respect to each other, right? So sometimes the constitution does come in conflict with religious texts. You can't hide from it. It is a reality. The constitution and the idea of equality within the constitution does come in conflict with the religious text. The question is how to reconcile them. Yeah, I think that's about it. Nobody is asking any other question.
Any other doubts?
I hope it was clear. I hope people understood. I hope it wasn't. I hope it was interesting. Okay, enough. Yes, yes. Thank you.
Hello.
Yes, ma'am.
Can you
I
hear
can
me?
hear you.
Yeah.
Yes, ma'am.
So thank you so much.
Yeah. Welcome. Thank you. It is my pleasure.
It was lot of informative, and our students hope they have understood the concept. Guys, I hope you
Yes,
have
I hope.
understood the concept.
Yeah, I hope too. Mm.
Okay, on behalf of IFM, sir, thank you so much.
Thank you, ma'am.
Take care, sir. Bye.
Thank you. Bye. Take care. All the best.
Hello. Hello, can you hear? Guys, can you hear me? Yes. Third years, since it's there in the timetable, please mark your attendance here in the LMS. Fourth years and the remaining ones who have joined, please write your name. Like how you mark everyday attendance, same way Ritvika. Clear? Same as you mark your daily attendance. Yes, under family law 2. This session has been scheduled under family law 2 class. An extra class this week. For 30 minutes. Others will also get attendance for guest lecture.